And good. What are we doing with Mr. Lundy today?
Uh, Sir, Mr. Lundy would like to talk about the possibility of a non-negotiated plea. If you look at the terms that the state is recommending, among other things, it includes no contact with his life partner, Tierra Hood, and to stay away from his home, which is 1474 Venetian Drive. Mr. Lundy understands all the other terms of probation and accepts all the other terms, but he has a 1-year-old daughter who has cerebral palsy with Ms. Hood, and he's one of her primary caretakers. And so he was hoping that no contact could be transitioned to no future contact, and he'd be allowed to remain in his home, to remain as one of the primary caretakers for his daughter.
Okay. Let me see. Ms. Falk, has your office had the opportunity to speak with Ms. Hood regarding this?
Your Honor, our last update was that we had not been in contact or had not had successful contact with Ms. Lundy. Ms. Hood, excuse me. The issue here, however, is, and let me just pull up something really quickly. So,
Ms. Hood, it looks like Ms. Hood is here, so maybe she can speak for herself. I didn't want to interrupt you, Ms. Falk. I just wanted to.
No. I do just want to point out something briefly, if I may.
Okay. Yes.
To the defendant's history, he has a 23 SC 186603 case. That case was an indictment for, let me see, it was aggravated assault, 2 counts, cruelty to children in the 3rd degree, 3 counts. The aggravated assault was against Miss Tierra Hood. As a part of that plea, back on April 7th of 2023, the defendant was given 3 years, served 6 months, balance of 2 years, served 6 months to be served on probation. And as to the remaining counts, 12 months to run concurrent. As a part of that, there were special conditions, one of which was no direct or indirect contact with the victim, Tierra Hood. The problem is that the defendant is in violation of that probation simply by being in contact with her when this offense happened. And that is why the state is objecting to any contact. It's because there is a felony probation that is preventing him from having contact, of which he's in violation of. And I believe that is one of the reasons he is in custody, is due to that probation violation. Just let me, and that's what I was going to say, let me double check on that. He is not. However, we have alerted the DA's office to the fact he is in violation of his probation.
Okay. So,
can I see?
Yes, ma'am, but give me a moment. I'll get to you in just a moment, ma'am. Okay.
And I can go over the facts of this case if Your Honor would like, and go over the plea recommendation from the state.
Okay, I'll be happy to do that. I just want to make Ms. Vigiletti and Mr. Lundy aware that regardless of what this court does, that there is already in place a no further contact and a stay away. So I don't know why it would hamper a negotiated plea in this matter, since he should not be around Ms. Hood.
Your Honor,
regardless.
Both Mr. Lundy and Ms. Hood have told me that their understanding of Judge Richardson's orders was that the contact was no future violent contact.
And Your Honor, I can send the sentence order over that directly contradicts that. It says no direct or indirect contact with victim Tierra Hood on the sentence sheet.
Okay, so that would, I think that would clarify the issue. So
yes, Your Honor. I'll send that over to you and Ms. Vigiletti.
Thanks. Thank you very much. Now, Ms. Hood, while you discuss that, Ms. Hood,
Can I speak?
I'm going to allow you to speak, ma'am. But
Okay.
first, what I want you to do is I want you to find a steady state for me. So I don't want you to be moving around.
All right.
Okay. Now, raise your right hand for me. Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay. Thank you, ma'am. You can place your hand down. What would you like to tell the court?
Okay, now look, we did have an altercation before this even happened, but see, if you go back and look, sir, the last court that he went to before he got out the last time, they did put that he could have a physical contact with me and be in the home with his daughter. And if you go back and look, I even sent it to Ms. Smith, his probation officer. He do have the right to be here. But like I said, the officer, we was arguing outside and stuff, and the neighbor called the police and stuff, and he said he wasn't gonna lock Marcus up. He was not. That's why he put assault, because he had no reason to lock Marcus up. And so if Marcus would have been quiet, and when the officer told him to be quiet, then he wouldn't have been in there. But we did not get in no domestic violence, or he didn't hit me. He didn't do nothing there. We just was outside. We was having fun outside, and we was loud. We were having the kids like the New Year's or whatever, But he did not touch me. He did not physically hit me. He didn't do nothing. So that's why I don't get when she's talking about, yes, he did have previous, domestic, but this not a domestic case. This not domestic case. If you run it back, the man wasn't even going to lock Marcus up, but Marcus was, talking. He was a little tipsy. I'm not going to lie. He was a little tipsy. But other than that, because he kept talking junk, and so that's when because he wanted to shut up. He wasn't shut up. Like every man think he could do what they want. He wasn't shut up. That's why the man locked him up. And he just put that on him.
Okay. Thank you, Ms. Hood. So, where are we? Did you? I received your email, Ms. Falk. I do believe that they're not supposed to, regardless of what you say, Ms. Hood. The order that was entered says that there's to be no further contact.
Your Honor, if I may.
My bad. You can.
I do still need to put the facts on the record as well as the state's recommendation.
I haven't really started yet, so let me do this. I haven't even addressed Mr. Lundy yet, so let me go ahead and address Mr. Lundy, and let's do this the proper way that we normally proceed. So, good morning, Mr. Lundy. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Okay, can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Thank you, Mr. Lundy. Given what you've heard, Ms. Vigiletti, what are we going to do with Mr. Lundy this morning?
If Mr. Lundy and I could just have 1 minute, please.
Okay, so if you want to put yourself on mute and speak with him.
And Your Honor, I do need to correct something on the record, and I do need Ms. Vigiletti to hear this part. Based on what Ms. Hood was saying about it being a probation revocation, that something had happened at probation revocation, I went back and looked through the case, and I did find a consent order from September of 2023 as part of a probation revocation where the contact was modified to no further violent contact. It's not something I would have normally even seen because we don't normally go through all the probation violations in a felony case. But it does seem the order was modified in September 2023 based on a probation violation consent order. I will say the state is still asking for no further contact because this incident happened 3 months after that modification.
Okay. Given what
I did email that to both parties, Your Honor, and to Ms. Vigiletti.
Okay. Given what Ms. Hood has testified as to this morning, and that order was modified, it will be in a non-negotiated plea, if that's what we have to do, it will be a no further violent contact with Ms. Hood.
Your Honor, and before you make that determination, I would still like to put the facts on the case so Your Honor can hear about what happened that evening from the state's perspective and what she told the police that night.
Okay. So let me start with, yes, Ms. Falk, go ahead.
This incident happened on December 24th, 2023. Officers came out to They spoke with Miss Tierra Hood at the scene. She said she was in a physical altercation with Mr. Lundy, and she further stated that she was arguing with him and he attacked her. Miss Hood stated to the police that Mr. Lundy struck her in the head and all over her body, and that she was in pain, but she couldn't go to Grady due to her children being home alone. Officers then spoke to Mr. Lundy, who stated he was out. Miss Hood was mad at him, and that he did not attack her. However, based on Miss Hood's statement that he struck her physically all over her body, he was placed under arrest. So I just want to point out that although Miss Hood is coming into court today and saying this was all a misunderstanding, that is very common in a cycle of domestic violence such as the one we have, where the defendant has already been convicted of domestic violence against her. The order was modified to allow them to have contact, and within 3 months of the order being modified, there is another call out by police to that location based on him attacking her. And so for that reason, we are asking to go back to the original condition that was imposed in April of last year, that there be no further contact, due to the fact that, again, 3 months after they modified it, we are back here again on a new offense of simple battery family violence. The state's recommendation as to this case is going to be, let me just pull that up really quickly, is going to be 12 months, serve 80 days, credit for time served 17 days from December 24th, 2023 to today. Balance probated, family violence intervention program, 40 hours community service, no contact with Ms. Hood, and stay away from no alcohol, drugs, or weapons, and no firearms.
Can I speak?
Give me a moment, Ms. Hood. Find a steady place, Ms. Hood. Okay, you're still under oath. What would you like to tell the court?
Well, like I said, we was arguing. We were arguing. The only thing we were doing is arguing. But if you think, if he would have beat me now, I've been in a relationship with my ex, Montrez Berry, where when he hit me, they had photographs and stuff like that. So if that officer told y'all that he beat me, why ain't nobody came out here with no picture of a bruise on me? That's a question. Cause I have a domestic violence with my ex. My ex, his name Montrez Berry. But good job. And he used to beat me. And when he did that, they had the people come out, take pictures and stuff like that. He wasn't even there. So the officer didn't have no reason to lock him up. He just put whatever he said. Cause if look how big he is, ain't no bruise on me, sir. Ain't no bruise on me. How you gonna say, you look how big he is, look how small I should have a bruise on me. I should have a bruise on me. Ain't no bruise on me. Ain't nobody took no photograph.
Ms. Hood, do you and Mr. Lundy have children?
Yes, we do. You want to see her?
No, I just want to. No, I do not want your children involved.
But
in
yes,
this.
we do. She's deaf. We take deaf classes together. She's got the G tube on her stomach and stuff. We take time feeding her because sometimes I have hard times waking up in the morning feeding her. So yes, he take that role. He always do. He always do. We go to every doctor. We go to the max feeding. We go to everything together. We do.
Okay.
But the thing about it, the officer wasn't going to lock him up, sir. That's the only thing I'm saying. He wasn't going to lock him up. He told him to lay it down. But when Montrez, I ain't going to lie, he was. He was drunk. He was drunk, and he was talking junk to that man. And that when he locked him up, because he didn't have no thing. Because if you say, look, I'm small, and compared to him, he's a big dude. And so if he hit me, sir, I should have a bruise on me. I should have a bruise on me.
Okay,
I
you've
should
said
have a
that,
knot
Miss.
on my head.
You've said that, Miss Hood. Thank you, ma'am. Let's see, Miss. Before I make my decision regarding contact, Miss Vigiletti, is there something that you would like to address the court?
Yes, if I may, just to emphasize what Ms. Hood was saying, Mr. Lundy is the primary caretaker of their 1-year-old child with cerebral palsy. That was his primary concern when we spoke yesterday, needing to live in the house with such a young child that has so many medical needs.
Anything further?
No, sir.
Oh, Dr. Long fled. I'm not able to take the flare right now, but in the treatment.
Your Honor, and if the state can inquire with Ms. Hood, who called the police?
Miss Hood, are you with me?
I'm right here. What she say? My bad. What she say?
Who called the police?
The neighbor. One of these neighbors that were riding down the street, I guess they were having a party and they just seen us just arguing. But it wasn't nothing like that because he was saying there's us to be quiet. But Marky wanted to be quiet. But a neighbor called the police. I didn't call the police. My phone was off.
And Your Honor, just to update you, because I am reading this warrant, and just to update you, according to the warrant, Mr. Lundy did state, it says, while I was giving Ms. Hood the case number, Mr. Lundy stated he had slapped Ms. Hood before she had called the police. And at that point, he was detained and placed in the back of the patrol car. And that is part of the warrant. That was probable cause was then determined on. So there is an admission by Mr. Lundy as well as by Ms. Hood as far as December 24th, 2023. I understand that everybody has kissed and made up, but that does not change the facts on the ground, nor does it change the fact that there is a felony conviction involving abuse to Ms. Hood already.
But ma'am, excuse me. Like I said, Marky didn't have no phone. And like I said, he was drunk. Drunks talk stuff. Drunks talk stuff. He always talk junk.
Ms. Hood, may I recommend that you just pause now, okay?
Okay.
Okay, thank you.
All right. If there's a non-negotiated plea, Ms. Vigiletti, if I allow there to be contact, I'm also going to require that there is drug evaluation, drug and alcohol evaluation and treatment. If necessary, I'm also going to require that he get random drug and alcohol screens.
No problem.
Okay, sir, we are prepared to agree to that.
Okay. Anything further from anyone prior to taking a non-negotiated plea?
No, Your Honor.
Yeah, I did have the services today.
No, sir, we're gonna plead.
Okay. Mr. Lundy, it's my understanding that in case 23 CR 008225C, you wish to plead guilty to simple battery family violence. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, I'm very pleased with it.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept the plea. Mr. Lundy, this court sentence will be 12 months to serve 180 days, credit for time served 17 days. The balance will be probated, a family violence intervention program, drug and alcohol evaluation and treatment if necessary, random drug and alcohol screens, 40 hours of community service, no further violent contact with Ms. Hood, and no drugs, alcohol, or weapons while out on bond.
And Your Honor, I don't think we got this on the record because this was a little disjointed. But we do need the defense to stipulate as to factual basis, venue, and identification for the purposes of the plea. Ms. Vigiletti?
I'm sorry, Your Honor, we just needed to clarify the number of days in jail and the math and.
And while you were clarifying that, Ms. Falk asked a question. So could you repeat your question, Ms. Falk?
Yes, Your Honor. We just need the defense to stipulate to factual basis, venue, and identification for the purposes of the plea.
We do stipulate.
Okay. Anything further on this matter?
No, sir.
All right. Good luck to you, Mr. Lundy.
Yes, sir.
Thank you, Judge.
Your Honor, next is Ms. Beaumont. Yesterday, she refused to participate in any way with anything, including Judge Shackelford, and pretty much the same thing today, but I'll let you give it a shot.
Sure, but as far as being arraigned, you just need to read it. Arraignment's an arraignment.
Beaumont, you want to talk to the judge?
All right. So, Ms. Beaumont, I'm Judge Slaven. Welcome to the 23rd District Court. How are you today? All right, so, Ms. Beaumont, if you can hear me, I want you to stand up on that bunk. All right?
What?
I said, if you can hear me, just go ahead and remain standing on the bunk there. That way I know that you can hear me, okay? I said, if you can hear me, remain standing on the bunk. Okay? So you can hear me? Okay. I'll note that you shook your head yes there. This is case 240027SM. It is alleged, and you do have the right to remain silent. Anything you say can and will be used against you at court. You also have the right to an attorney. You cannot afford an attorney. One will be appointed to you by the court at public expense. So, would you like a court-appointed attorney? No? Okay, well, you can still ask for one at the next proceeding. I am letting you know today's the date and time set for an arraignment. So I'm going to let you know what you're being charged with, what they're alleging, and what the penalties for that, alleged penalties could be for that. So it is alleged that on or about the 6th of the January 6th of 2024, that you, in count one, that you committed the crime of domestic violence, and that you allegedly did make these tubes are so loud. That you did make an assault or an assault and battery upon an individual by the name of Teauna, T-E-A-U-N-A, Marie Hamilton, a resident or former resident of your household. And that's contrary to Michigan Compiled Law 750.81, subparagraph 2. Now, that is a misdemeanor. That's punishable by 93 days in jail and or up to $500 in fines. So, as to that plea, how do you plead? Guilty or not guilty? Or you can stand mute and I'll enter a plea of not guilty on your behalf. Okay, I'll give you 5 seconds to go ahead and think about whether you want to plead. And if I don't hear anything from you, I'll find you as standing mute. 5, 4, 3, 2, 1. All right, I'm going to enter a plea of not guilty on your behalf, because I want to make sure that your constitutional rights are preserved. I'm going to set this up for a pretrial. So the next thing, and if you want to talk to me about your bond, because I'm going to determine whether or not what your bond should be. So if there's anything, and you do have the right to remain silent, anything you say about the case can and will be used against you. So I'm going to see that you've been living in the city of Taylor. Does anybody know if the victim live in the same residence?
Yes, Judge.
All right, so do you have somewhere else to stay other than the? No? Okay. Then I'm going to go ahead and set a reasonable bond in this matter. I get the situation here. I'm going to set it for $250 cash or surety. No leaving the state of Michigan without the consent of the court. No contact with the victim or victim location. No use or possession of any weapons, firearms, or ammunition. All right.
Could you mark the file for mental health? Judge?
I am going to mark the file for medical because I just want to make sure that everything's okay with you and that you're understanding everything that's going on. So, Ms. Beaumont, you'll be getting a date and time of when your pretrial will be. Again, if you want to renew at any time a request to have court-appointed attorney, the court will grant that. And in the meantime, have a good rest of your day.